Good afternoon. This is Kirti Satvika, your court master.
Master, yeah.
Good afternoon, everyone. I'm Rajiv Varsha, your court master.
Okay.
We are honored to have with us Honorable Justice Srimati P. Sree Sudha ma'am and Honorable Justice Srimati Surepalli Nanda ma'am, sitting judges of the Honorable High Court for the state of Telangana, for adjudicating final rounds of the 4th National Moot Court competition organized by Thomas George and Associates. We will now proceed to explain the time division granted to each counsel in the competition.
So time will not be extended. Whatever time is already fixed, that only will be granted.
I will proceed to explain the court timings.
Yes, no further extension.
Each team will be allocated 30 minutes each, and each speaker will be allotted 15 minutes. If you want any changes, please request the bench. And placards showing...
No further extensions. No further extensions. Whatever is already given, within that time, they should finish.
And
by the timing. You specify the timings already fixed up.
Should I repeat the timings, ma'am?
Yes, repeat it.
Each team will be allocated 30 minutes each, and each speaker will be allocated 15 minutes. If you want any changes, please request the bench. Placards showing 5 minutes over, 3 minutes over, and time up will be shown. Rebuttals are left in the discretion of the bench. I request the petitioners to take over.
Yes.
May it please the court, the counsels for the petitioner have herein approached this honorable court through a public interest litigation under Article 32 of the Constitution of Indigo in the matter of Jan Seva versus Union of Indigo. With the kind consent of the bench, the counsels would like to refer to your leaderships collectively as honorable bench.
Yes.
Much obliged, your leadership. The counsel seeks permission to share the compendium. Given the size of the compendium, we shall be presenting the comprehensive compendium for the convenience of the bench. Shall we proceed?
Yes.
Much obliged. There are 3 issues. As the first speaker, I shall be dealing with a brief legislative history and the first issue, whereas my co-counsel shall be dealing with issues 2 and 3. With the kind consent of the bench, the counsel would like to deal with the facts of the case and the brief legislative history of the same. Shall we proceed? Much obliged. To talk about a brief history of the system of governance in Indigo, Indigo happens to be a sovereign, socialist, secular, democratic, and republic state, and functions under a federal system of governance. Taking inspiration from the Westminster model, Indigo follows a parliamentary democratic form of government with a bicameral system of legislature. The Election Commission over here is an independent body to ensure free and fair elections in Indigo. Further, we have the Lok Sabha and the Rajya Sabha, where in the Lok Sabha, we have elections every 5 years, and these are direct elections, whereas in the Rajya Sabha, we have indirect elections every 6 years. To talk about the anti-defection law, with the advent of horse trading and follow crossing practices, the anti-defection law was brought in the Constitution 52nd Amendment Act in 1985. And to avoid disqualifications under the same, the splits and mergers in political parties became prevalent. To give a brief legislative history of the same, in 1967, we had the Chavan Committee that gave recommendations to curb the practices related to defections for the very first time. Further, we had several amendments to the constitutions, but the 1985 Constitutional 52nd Amendment Act was passed, and that gave Indigo its first anti-defection law. It brought in amendments to the provisions of Article 101, Article 102, Article 190, and Article 191 to the Constitution to provide grounds for vacation of seats for the disqualification of members. The 10th schedule that was inserted disqualified defecting members from the House, with an exception of splits and mergers. In 1992, we had the Kyoto Holuan versus Zachilu judgment that upheld the validity of the law, except for the part of judicial review. And in 2003, given the widespread criticisms of the provisions related to split and merger, the Constitution 91st Amendment Act was passed, and that omitted the provision of splits, but the provision of mergers remained. So your Honorable Bench, I shall just go on to talk about the 10th schedule briefly and then move on to my first issue. The first paragraph talks about the interpretations, wherein we find the definitions for the term House, the term legislature party, the political party, wherein if we were to draw a Venn diagram, the legislature party forms a smaller circle within the bigger circle of the political party. The second paragraph talks about the grounds for disqualification. Third, used to talk about splits, that has been removed now. The fourth paragraph talks about exemptions in the cases of merger. Fifth, exemptions for speaker. Sixth, for the decision of the chairman or speaker to be final. The seventh used to talk about the bar for on jurisdiction of courts to be deemed invalid, and that was deemed invalid in the Kyoto Holo judgment. And the eighth talks that the rules can be made by the speaker or the chairman. With the kind consent of the honorable bench, the council shall now move on to the first issue.
Yes, permitted.
Much obliged. His lordship, if we were to talk about the first issue, we deal with whether the anti-defection law exhibits notable deficiencies concerning the element of voters' trust, thereby necessitating amendments. Honorable bench, his lordship Justice Krishna Iyer severely criticized the anti-defection law, or rather the electoral politics and flow crossing practices even before the anti-defection law existed. In the Narendra Mandiwala Parakheni versus Manikram Patel judgment of 1977, he remarked that the grinds relied on a shifting sands to build a firm finding upon, knowing how notorious is the cute art of double crossing and defection in electoral politics. The 10th schedule that was subsequently added in 1985 was brought in under the recommendations of the Chavan Committee and was primarily to stabilize the government and bring discipline in the parliament. Further, the Kyoto Holo judgment of 1992 was a landmark judgment. However, standing in 2023, what was held in 1992 cannot stand true because the current nature of floor crossing and horse trading has evolved since then. And thereby, that makes us invoke the principle of transformative constitutionalism as held in the Navdeep Singh Johar case. With your kind consent, I shall move on to the first sub-issue.
Yes.
Much obliged. The first sub-issue talks about provisions pertaining to mergers and post-poll alliances that do not stand true to the test of reasonableness. Honorable bench, the provisions of split and merger, that is paragraph 3 and 4, are provisions that dealt with bulk defections. And both of them are to be done away with. However, as per the 91st constitutional amendment, only para 3 or split was removed. Now, bench, this was not the council's own words, but we find that various committee reports, like the Halim Committee report in 2003, the 170th LCR report as has been presented here, the second Administrative Reforms Commission, and the National Commission for Review of the Working of the Constitution report. All of these have indicated the same things time and again. However, they seem to point out that what happens is, be it 1/3 or 2/3 or whatsoever, the bulk defection was being allowed. And the merger problem still remains, whereas only the aspect of split was removed. And why do we consider merger to be a problem is if we were to look at the years from 1990 to 2004, that is a span of 14 years, Honorable Bench, we find that there have been 81 defections since then. And post that, there have been many more. So there is no plausible logic, Honorable Bench, for keeping the merger provision, whereas we remove the split provision only. Further, talking about the post-poll alliances or coalitions, Honorable Bench, let it be noted that these governments come together only for the sake of coming into power. They may consider smaller parliament governments as well. And the only thing that they have in common is their need, or rather their wishes to come into power. And later that goes on to cause ideological clashes, and eventually these governments fall out. Again, these are not the council's own words. If we were to look at the compendium that's being shared here, we find that in Karnataka in 2019, there were 17 MLAs from the ruling coalition, they backed out from the government. Whereas in Maharashtra in 2022, 40 out of 55 members from the Shiv Sena party or the coalition, that was between Shiv Sena, Indian National Congress, and the National Congress Party, they backed out. This proves that the very instability that the anti-defection law tried to remove, it is failing to do so, Honorable Bench. Moving on to my next sub-issue, if there are no questions, I shall deal with how the party tickets have no legal recognition.
Now, before you go to the second part,
Yes, Honorable.
the anti-defection provisions were inserted into the constitution by which constitutional amendment?
The 52nd Constitutional Amendment in 1985, Honorable.
The Amendment Act introduced made changes to which two articles of the Constitution?
The 91st, which two articles of the Constitution?
Yes.
The articles 109, we dealt with 109, 102, 190, 191, 101, sorry, not 109. These are the four provisions that were dealt with. You have mentioned the same in the legislative history, Your Ladyship.
Yes. Does the Constitution define the term anti-defection?
the Constitution does not talk about the anti-defection word itself, but it brings in the aspects, and of course, you can see the mentions of the same in all of the committee reports, and that bit brings the term itself.
What are the grounds under which a legislature can be disqualified?
Grounds under which a legislature can be disqualified.
Legislator
can be disqualified, yes.
Yes.
My co-counsel is also going to speak on the same, but if we look at provision 2, the disqualifications paragraph rather, we may find that if they voluntarily resign or if they speak against the party views itself, be it inside the parliament or outside the parliament. And for the legislature, if we are talking about the speaker, then they come in if they change it after 6 months of their tenure. But for the legislature, right after the election, if they plan to change the same, they will get disqualified.
Can convicted legislators be disqualified from assembly?
And convicted legislature, that I believe if we are talking about the anti-defection law in particular, then not exactly, unless they are removed by the party itself. Because the very anti-defection law talks about the seats over here.
Under what conditions can an MLA MP sentenced by the court be removed from their positions?
I didn't get your ladyship.
Under what conditions can an MLA MP sentenced by the court be removed from their positions?
On the grounds, if you're dealing with the anti-defection law on the grounds that they have gone against the party views and perhaps abstained from or rather have voted against the same. And besides that, if there is any provisions which talk about the provisions or rather they are defecting their very own party, then they may be removed from the seat, your leadership.
Yes, you can go to the another question.
The next issue?
Yes.
Okay. Much obliged, your leadership. Moving on to the next issue, it is humbly submitted that, or rather when we're talking about the party tickets, that they have no legal recognition, it is humbly submitted that the anti-defection law is premised rather on the candidate's loyalty to the party. However, it is to be noted that the constitutional morality and social morality are two very different things, Honorable Bench. As held in the Keshananda Bharati judgment, it is mentioned that when parties go to election, they bring out a lot of promises. However, the same does not bar the candidate from exercising their freedom of speech. Thereby, if we remove, or rather, if we talk about the laws, there exist no laws that strips them of the freedom of speech. And this has been elaborated again in the 2016 Election Commission of India report, where it tries to institutionalize the party tickets by placing a model code of conduct as it's presented over here. And this is thereby trying to remove the ideological conundrums that currently exist. Honorable Bench, if there are no questions, I shall move on to my next sub-issue.
Yes, proceed.
The intra-party deliberative and dissuading mechanisms must be enforced. Honorable Bench, it is submitted that the anti-defection law should not be brought to ensure intra-party discipline or any other political problems. If a party member does not believe in your party's views, then they may be removed from the party. But using whips as a means to take their seat away is unjust, as it curtails the freedom of speech. Further, we could just take an inspiration from the model code of conduct that exists in the United Kingdom, where they are removed from the party if they defect, but that they still retain their seat, Honorable Bench. That is the 3 lines whips as has been mentioned in the compendium here. Honorable Bench, if there are no questions, I shall move on to my next sub-issue.
Yes, proceed.
Much obliged. The next sub-issue talks about destabilizing the government through mass recognition has become a common practice and needs to be addressed. Honorable Bench, as it has been submitted earlier, mass resignation has become a common practice, as we could see in the states of Karnataka, Maharashtra, Madhya Pradesh, and Goa, as we'll find in the next slide as well. And this needs to be stopped because these causes nothing but instability in the government, and that turns the majority government into a minority one. And that is one problem that perhaps the anti-defection law, again, sought to curtail or rather stop, but it has been failing to do so. Honorable Bench, if there are no questions, I shall move on to my final sub-issue.
Yes, proceed.
Much obliged, Honorable Bench. So, coming to my final sub-issue, that the law has no provision for members expelled by the political parties. All right. It is humbly submitted that none of the 8 provisions in the anti-defection law talk about the expelled members. There exist various conflicting judgments on the same, however, with the 1996 Supreme Court judgment of G. Vishwanathan versus Tamil Nadu Legislative Assembly, stating that the expelled member shall remain to be a part of the original political party. However, in the 1998 Dr. Wilfred A. D'Souza versus Sree Thomasino Cardozo case of the Bombay High Court, we find that it mentions that these members will not be considered a part of the party anymore. Honorable bench, as I bring my submissions to a wrap, this is one question that I pose to myself, as is what happens to the member, and can whips still be imposed on them? This is one question which I hope the court can shed some directions upon. And I shall now request my co-counsel to proceed with issues 2 and 3. And it was a pleasure arguing in front of this honorable bench. Thank you.
Yes, proceed. The second counsel on behalf of the petitioner.
May it please the court. This is Drishti Banerjee, the second counsel on behalf of the petitioner, and I shall be dealing with issue 2 and issue 3. Honorable Court, the second issue that we have posed before this bench is whether the non-recognition of the right to dissent breaches the norms of the Westminster system of parliamentary democracy. Honorable Court, I would like to present our submissions on part of the party whips that is enshrined under paragraph 21B of the anti-defection law, that is Schedule 10, which reads as if he votes or abstains from voting in such house contrary to any direction issued by the political party to which he belongs, then such member or legislator shall be disqualified. Honorable Court, if this provision is read with Rule 2F of the Lok Sabha rules, which is there in the next page, it defines who is a leader of the party and who shall issue these directions. Honorable Court, it is a humble submission on behalf of the petitioners that these provisions have no rational nexus with the object sought to be achieved by the anti-defection law, which is mentioned in the statement of objects and reasons itself, that is, with the stability in the government. Honorable Court, there are various motions that can be presented in the House that have no direct nexus with it. For instance, the votes by the opposition party MLAs or the MPs of the Rajya Sabha, or a motion for the removal of the Honorable President or Honorable Chief Justice, or any such motions, they have no rational nexus with maintaining the stability of the government, and in such motions, curtailing the freedom of speech of the legislator is not justified. Honorable Court, on this behalf, I would like to reiterate the case of Keshavananda Bharati versus State of Kerala, 1973, where it was observed that it is hazardous to rely on parliamentary debates as aids of statutory construction because, Honorable Court, it was held that since all the legislators have now become merely whatever the party views are saying, they are going and saying the same things, then parliamentary debates are losing their originality. Honorable Court, in this regard, the Dinesh Goswami Committee had made a recommendation, a very pertinent one, that the issuance of whips could be restricted to confidence and quasi-confidence motions only. For instance, the money bills and the no confidence motions that are very serious in nature, Honorable Court. So that is why the council feels that this term, any direction issued by the political party, is very contradictory or controversial in itself. Moving on, Honorable Court, the legislator might defect for various purposes. It could either be for certain vested pecuniary interest, or perhaps he voted other than the party direction or party line because he believed it to be true to the goals of his constituency, Honorable Court. So, in disqualification proceedings, if the legislative intent behind such defection is properly interpreted, then it adds to the fairness of the procedure, Honorable Court, which is not done in the instant matter and thereby violating Article 105 and Article 122 of the Constitution of India. Honorable Court, Indigo follows a representative democracy and a responsible form of government. Responsible form of government where the elected representative is responsible towards his constituency. Honorable Court, it was reiterated in the case of Kuldeep Nair versus Union of India that we do not follow a system of proportional voting. In proportional voting, the voters vote for the particular political party. However, in our system of voting, they are voting for the candidate. And what is the correct definition of the word candidate has been given by the very same judgment. It has been said that they are the people chosen to represent their several interests in the parliament. Honorable Court, in such a system of parliamentary democracy, which forms a part of the basic structure of the constitution, if those restrictions are imposed that are not just, fair and reasonable, then Honorable Court, these provisions need certain modifications. As His Lordship, the Chief Justice of India, Dr. T.Y. Chandrachud, recently mentioned that the minority voice should also be given importance in a democracy. So these practices that curb the freedom of expression of the legislator should be brought under control. If the bench has no further queries, then I may move on to the next issue that I have in hand.
Before you go to the next issue, few questions from the bench.
Indeed, much obliged.
Is there a time frame in which Speaker of a Legislative Assembly should decide on a petition seeking disqualification of a member under 10th schedule of the Constitution?
Honorable Court, there is no such provision of law under which the Speaker is time-bound, but there is a judgment of this Honorable Court where it was mentioned that it has to be done within the period of 3 months. The judgment is S.A. Sampath Kumar versus Kalai Adaiya, also followed by Kesam Mangal Chandra Singh versus Manipur Legislative Assembly.
Should judicial review cover any stage prior to the making of a decision?
Indeed, Honorable Court. Yes, this question was first dealt with in the famous case of Kishwanand Kihoto Holohan versus Zachilu, where it was mentioned that judicial review would cover the proceedings of the parliament in 2 cases. For the substantive part, if there is any violation on the grounds of malafide intention, violation of constitutional mandate, non-compliance with the principles of natural justice, perversity, etc., then judicial review can be done. On the procedural aspect,
you did not
yes.
understand the question of the court. The query of the court, the query of the bench is, should judicial review cover any stage prior to the making of a decision? By the
Indeed, Honorable Court, in Kihoto Holohan versus Zachilu, it was mentioned that in no stage prior to the order of the court, order of the Speaker, the court can intervene. But recently in Subhas Desai versus Governor of Maharashtra, it was observed that if in the procedural stage also there is some violation of democratic functioning, then the court may intervene and may take certain decisions.
Would intervene
The 2023.
permissible at an interlocutory stage of the proceedings?
I did not get your question, Honorable Bench.
Would interference be permissible at an interlocutory stage of proceedings?
At interlocutory stage, Honorable Bench, as I already mentioned, generally it is not allowed. But if the qua time provision that was mentioned in the Kihoto Holohan judgment, that provision is breached, then it will be allowed.
Don't you think Parliament should amend the Constitution to provide for an independent mechanism such as permanent tribunal headed by retired judges to decide disputes under 10th schedule? What is your opinion on this?
Indeed, Honorable Court, that would be my next issue. So if I may be allowed to delve into it in detail, or should I give a brief answer for now?
You go to the next issue. Permitted.
Much obliged, Honorable Bench. So the next issue deals with whether certain regulations pertaining to the proceedings of disqualification are called for. Under it, Honorable Court, my first submission is that an independent adjudicating authority, as this Honorable Bench only suggested just now, could decide the cases of disqualification. Honorable Court, this is because the Speaker is a part of the Parliament or the Legislative Assembly. He or she is an interested member, thereby violating the provision or the principle of natural justice, nemo judex in causa sua. Honorable Court, this very thing regarding the biasness of speakers has been held by this Honorable Court in various judgments. For instance, Balachandraji Jarioli versus B.S. Yediyurappa, Dr. Wilfred D'Souza versus Tomasino Cardozo, Nabam Rebia versus Deputy Speaker, Raj Narayan Singh versus Atmaram Govind. All these judgments, Honorable Court, deal with the fact that the Speaker can be biased, and he can act in a partisan manner. Adding to that, Honorable Court, under Article 103 and Article 192, all the proceedings of disqualification of legislators are dealt with either by the president or by the governor, as the case may be. The only exception is provided for the 10th schedule for the anti-defection law cases. So the council asks this question to herself: what is the reason behind providing this exception to only one provision, that is anti-defection law? What is the rationale behind this exception? Adding on to that, this is not only the council's submission, various committees and commissions have added on to the same thing, like the Dinesh Goswami Committee of 1990, the Second Administrative Reforms Committee of 2007, Background Paper on Electoral Reforms 2010, National Commission on Review of Working of Constitution 2002, 170th Law Commission Report 1999, and 255th Law Commission Report 2015. Honorable Court, if we are to draw comparative jurisprudence from the Commonwealth democracies that have a similar structure of parliamentary democracy, for instance, in Papua New Guinea, in Namibia, independent bodies adjudicate upon disqualification proceedings. Honorable Court, for instance, in Papua New Guinea, there is this ombudsman tribunal that deal into the matters of corruption. They only decide the matters of disqualification as well. So in light of all the statements that I just made, we humbly submit before this court that an independent tribunal should decide these matters, and in a time-bound manner of 3 months. That has already been suggested by this honorable court, but no law has been brought into force till date regarding this. Honorable Court, also, I would, for the sake of repetition, the scope of judicial review in cases of defection matters. In various cases, the court, in fact, intervened and made certain landmark changes. For instance, in Jagadambika Pal versus Union of India, the court itself passed the disqualification order. In Rajendra Singh Rana versus Swami Prasad Maurya, the court disqualified the members, defecting members. In Speaker of Orissa Legislative Assembly versus Utkal Keshari Parida, it had said that any member, and not only a member of a legislature party, can file a petition for disqualification. So judicial review, Aditya, you're not sharing the screen, by the way. Yes. So judicial review has been going on in the cases of disqualification on account of the biasness or non-following of the rules of natural justice and fair play in action, Honorable Court. So if I may wrap up with my last submission that deals with paragraph 21A, mentioning the term voluntarily given up his membership. Honorable Court, this thing that voluntarily given up membership has been interpreted by the various courts and various judgments and the various speakers in a number of ways. For instance, in Ravi Nayak versus Union of India, it was held that the voluntarily given up membership can be derived from the conduct of the legislator, be it inside the house or be it outside the house. In G. Vishwanathan versus Honorable Speaker, it was held that it can either be express or it can be implied. So this provision gives a wide amount of, discrepancies. And this honorable court has acknowledged this issue in the case of Prithviraj Meena, which is pending before this. And if these two petitions can be clubbed together and the court can pass an order in this behalf, the interpretation or the constitutionality of paragraph 21A of the 10th schedule. If the council may move to the last submission, honorable court, that is the prayer.
Yes, permitted.
Yes, Honorable Court. So to briefly sum it up, all the submissions that have been made, firstly, if the court may be pleased to amend paragraph 4 of the 10th schedule that talks about merger. Honorable Court may be pleased to incorporate judicial principles regarding post-poll alliances and coalition governments. Honorable Court may be pleased to emphasize legal recognition to party tickets, intra-party deliberative and dissuading mechanisms, and what the status of expelled members. Also, mass resignation of the legislators, which have become a common practice. The whips could be restricted to no confidence and quasi-confidence motions. The defection intent of the legislator should be taken into account. The adjudication should be done by independent tribunals in a time-bound manner. The scope of judicial review and the interpretation of voluntarily given up membership of the political party should be given uniformity in proceedings throughout the territory of Indigo. With this, the council rests its submissions. Honorable bench.
Yes.
It was a pleasure arguing before this court. Much obliged.
Who appears as counsel number 1 on behalf of the respondent?
Connection on behalf of a respondent, Your Lordship, the council seeks permission to collectively address the bench as Your Ladyship.
Yes, proceed.
The council is here for the respondent in the case of Jansiva versus Union of India. The council would like to mention the issues that the council would like to present in this case. If the lordships permit, the council would like to elaborate the issues.
Yes, proceed.
The first issue being whether the writ petition is maintainable. The second issue is whether the office of the speaker satisfies as an independent adjudicatory missionary. The third issue is whether the inclusion of 10th schedule in the constitution is violative of the basic structure of the constitution. Fourth issue is that whether the 10th schedule violates the rule of law under Article 14, 19 and 21 of the Constitution. If the lordships are okay with these issues, the council would like to argue for the first issue.
Yes, proceed.
Much obliged, lordship. The first issue being whether the writ petition is maintainable. The council humbly puts forth that is not maintainable on the ground that there is no infringement of fundamental right of the petitioner. The jurisdiction of the Supreme Court can only be invoked under Article 32 when there is an infringement of fundamental right. Here, the main purpose and objective of the 10th schedule is to discourage and curb the evil practice of the defection. This defection endangers the foundation of democracy and there is no violation of fundamental right in the first place, Your Honor. Also, it was in the case of Kyoto Ulan, the constitutional validity of 10th schedule is upheld. And also it stated that there is no infringement of fundamental rights with regard to Article 14, 19, 21. Also Article 105 and 191 is also not violated. Therefore, the council humbly puts forth that the petitioner lacks the sufficient locus standi in the present case. Also, the council would like to state the maxim that is interest publicae ut sic finus litium. It means that in the interest of state, there must be an end to litigation. As I already stated, in the Kyoto Ulan's case, constitutional validity was upheld. Thus, the principle of res judicata will be applicable. Any judicial precedent or a judicial decision should be accepted as correct and it should be followed in the subsequent cases. Therefore, the council humbly pleads before this Honorable Supreme Court that this writ petition is not maintainable, Your Lordship. If the Lordships are satisfied with the first issue, the council humbly seeks permission to proceed with the second issue. Lordship.
In the present case, has there been a derogation of fundamental rights guaranteed under Part 3 of the Constitution of India, Indigo?
Lordship, there is no fundamental right that is affected in the present case, Your Lordship. That is the council would like to mention with regard to third and fourth issue, Your Lordship.
But what is the latest law laid down by the Supreme Court on this aspect? Right to vote is a fundamental right?
Yes, Your Lordship.
What is the latest law laid down by the Supreme Court on this aspect?
The council
law is laid down by the Supreme Court on this aspect?
Right to vote is a fundamental right, Your Lordship, but in the present case, it is clearly stated that under paragraph 2, any direction that is given by the party. In this regard, any direction will also include no confidence motion. So, if there is a no confidence motion on with regard to ruling party, the ruling party members are under obligation that they should vote for their party. If that is not satisfied, if they are not voting for their own party, then the very foundation of the democracy, that is the stability and accountability of the parliamentary democracy, will be curbed in the present case, Your Lordship. That is where the council would like to state that there is no infringement of fundamental right.
The recent Apex Court judgment, the 5-judge Constitution bench comprising Justices K.M. Joseph, Ajay Rastogi, Aniruddha Bose, Rishikesh Roy, and C.T. Ravikumar. In the recent case, Anup Baranwal versus Union of India, was of the view that the right to vote is a constitutional right. However, in the same case, it was held by Justice Ajay Rastogi that right to vote is a part of fundamental rights. What do you say about this?
Yes, Your Lordship, right to vote is a fundamental right. But in the present case, the 10th schedule does not violate the right to vote, Your Lordship, because it is clearly stated in the part 3 that to fundamental rights there are certain restrictions. These restrictions are very necessary in for the stability of the government and also accountability of the government, Your Lordship.
Yes.
Much obliged, Lordship. The Council seeks permission to proceed with the second issue.
Yes, permitted.
Much obliged, Lordship. The second issue being whether the office of the Speaker satisfies as the independent adjudicatory machinery. The Council would like to argue in this second issue with two sub-issues. The first sub-issue being whether paragraph 6 is violative of rule of law. It is humbly put forth that chairman or a speaker is said to be the presiding officer when it comes to disqualification on the ground of defection. This is stated in the paragraph 6 and also the decision shall be final. It is humbly put forth that the speaker enjoys a very high status and position of great respect and esteem in the parliamentary tradition. With this regard, the council would like to humbly seeks permission to screen share the compendium of the respondent, Your Lordship.
Yes, proceed.
Much obliged, Lordship. This is Kyoto Ulan's judgment that the council would like to look into. Here, the council would like to specify that the speaker or a chairman is said to be a person who is acting as a tribunal in the first place. Also, the speaker or a chairman hold a very pivotal position and in the scheme of parliamentary democracy, and they are said to be the guardians of the rights and privileges of the houses. Also, they act as a tribunal, as I stated earlier. And also, this is a very important aspect in which it was upheld. The office of the speaker is held in high respect and esteem, and also is a very embodiment of property and impartiality. And also, and these statements are very necessary for the consideration of upholding the 10th schedule. It clearly stated that it does not violate the basic structure of the democracy. With this regard,
Yes.
with this regard, the council would like to mention that the rule of law that is embodied in the Article 14 are the basic structure, and paragraph 6 does not violate this law. It is humbly put forth that the office of the speaker satisfies all the requirement of independent and impartiality quality of the adjudicative machinery. Now the council would like to move on with the second sub-issue.
Yes, proceed. Permitted.
Lordship, the second sub-issue being whether the paragraph 6 is violative of Article 21. It is humbly put forth that the speaker holds a pivotal position in the scheme of parliamentary and is a guardian of the rights and privileges. Also, it is important to note that he is expected to do far-reaching decisions in the functioning of parliamentary democracy. The vesture of power to adjudicate questions regarding 10th schedule is said to be a very important decision, and also the speaker or a chairman is not said to be a person who is biased, because likelihood of political bias is unsound and rejected in the Kyoto Ulan's case. It is hereby the council would like to state that this power that is given to the speaker should be viewed as a trust, and it is coupled with duty to exercise the same with public and social interest. All the questions regarding the well-being of the house are the matters of the speaker concern. Also, it is important to note that in the Kesham Singh with the speaker, 3 month time period is given. Also, it is important that various suggestions were also given from time to time in order to make the speaker's position effective. So, just because there are a lot of misuses that is done in the speaker's position, the law should not be made invalid, Your Lordship. There are a lot of cases to substantiate that the speaker is a very neutral, is a neutral person. These does not come to the view of Supreme Court. Just because one or two speakers are violating this rule, it should not be held unconstitutional. This is the argument from the respondent side, Your Lordship. Also, it is important to know that paragraph 8 clearly specify the rules because the rules that is created by the speaker is in line with the principles of natural justice, and also the procedure mentioned under article 21 is said to be satisfied with this rules mentioned in the paragraph 8. Therefore, the council humbly puts forth before this honorable court that the procedure that is established by law is fair, just, reasonable, and not oppressive, and it meets all the requirements of Article 21. Thereby the council would like to mention that the speaker satisfies all the requirements of independent adjective machinery. That's all, Your Lordship. The council would like to invite the second council if the arguments are in line with the issues.
Yes, permitted.
So, my Lordship, the council number 1 is inviting the second council to proceed with the third and fourth issue.
This is the second council appearing on behalf of the respondents in the case of Janaseva versus Union of India. The council will be dealing with the third issue, whether the inclusion of the 10th schedule is violative of the basic structure doctrine of the Constitution. Fourth issue, whether the 10th schedule violates the rule of law under Article 14, 19, and 21 of the Constitution. And the two sub-issues under fourth issue, 4.1, whether the exempted cases and non-exempted cases under paragraph 4 of the 10th schedule is based on intelligible differentia and reasonable classification. 4.2, whether paragraph 2 is violative of the parliamentary democracy under Article 19, read along with Article 105 and 194 of the Constitution. If Your Lordship permit, the council would like to continue with the third issue.
Yes, proceed.
Much obliged, Your Lordship. Issue number 3. Whether the inclusion of the 10th schedule is violative of the basic structure doctrine of the Constitution. The council would like to begin the arguments by stating that the basic structure doctrine is a constitutional creation, whereby certain features of the Constitution of India, Constitution of a country, are beyond the limits of the amending powers of the Parliament. An illustrative list was provided in the Keshav Nanda Bharati case, but the council would like to highlight, as quoted in the judgment, a sovereign democratic republic, parliamentary democracy, and 3 organs of the state certainly, in my view, constitute the basic structure. Accountability and stability is a key element of the parliamentary democracy. Therefore, it forms the fundamental structure necessary for the effective governance and accountability mechanisms. Para 2 and Para 4 of the 10th schedule merely prevents defection, thereby holding the elected representatives accountable for their actions, thereby maintaining a stable government. The genesis of the 10th schedule lies in the recognition that political defections represent a significant threat to the foundational principles of parliamentary democracy. The statement of objects and reasons accompanying the introduction of anti-defection law of the Constitution explicitly identifies the evil of political defections as a matter of national concern, necessitating decisive measures to curb the menace of defection. The crux of the rationale here in the anti-defection law, according to the National Commission to Review the Working of the Constitution 2002, is grounded in the idea that electoral victories of the candidates is also based on the party that endorses them, and defection, in essence, contravenes the very mandate of which a member was elected. Mergers are highlighted as exceptions under 4th paragraph because when 2/3 majority of the political party opts not to continue with the party, it is seen as an exercise of the majority views. And majority rule is one of the features of the parliamentary form of government. Further, the provisions for mergers is essential as it provides elected representatives with a legitimate recourse when in mass disagreement with their party's decision. It aligns with the democratic principles of considering the majority opinion within the party, ensuring that substantial portion supports any decision, including merger. The third feature of the anti-defection law is about the appointment of the speakers as the decision-making authority. It is justified on the grounds of internalizing political party matters within parliamentary boundaries. Acknowledging the importance of maintaining the democratic rights of the members, judicial review of the speaker was brought into view by holding the seventh paragraph unconstitutional in Quixote Hooligan case. Moreover, in Kesham Young Singh was a speaker, a 3-month period for the speaker to make a final decision was deemed reasonable. Hence, it is humbly submitted that 10th schedule is not violative of the basic structure doctrine of the Constitution, but merely a regulatory mechanism for defections in India. If your lordship has no queries, the council would like to move on to the.
Can decision of a speaker be challenged in High Court and Supreme Court? If yes, on what grounds?
The decision of the speaker can be challenged in the Supreme Court, your lordship, in the grounds that it is arbitrary and it violates principles of natural justice.
Yes.
If your lordship is.
Can you refer to any bench judgment on this issue?
Pardon, your lordship.
Can you refer to any recent bench judgment or any apex court judgment?
The council pleads ignorance for the same, your lordship. The council wishes to move to the fourth issue in hand.
In Rajaram Pal case, a constitutional bench of the Supreme Court clarified that it may judicially review a speaker's decision for illegality. Decision of a speaker can be challenged in High Court and Supreme Court in case of malafides, violation of principles of natural justice, colorable exercise of power based on irrelevant and extraneous considerations.
Yes, your lordship.
Yes. You can proceed.
Much obliged, your lordship. The fourth issue, whether the 10th schedule violates the rule of law under Article 14, 19, and 21 of the Constitution. It is humbly submitted that anti-defection laws, while viewed as a necessary evil, are essential to prevent continuous defection that could challenge the stability of the government. The right to freedom of speech of elected representatives, given the provision in the paragraph 2, subpara 1, Clause B of the 10th schedule states that a member who votes or abstains from voting contrary to the party decision can seek prior permission, or the party may condone the act within 15 days. Therefore, it is contended that when a remedy is available, it cannot be considered a violation of rights. The second feature of the anti-defection law centers around exemptions for the political party mergers. In case of Girish Chodankar versus the Speaker, Goa Legislative Assembly, the court held that legislators has an option to either support or oppose a merger. Moreover, paragraph 4 suggests the same. Therefore, it can be understood that there is no violation of Article 19. Merger is viewed as an exercise of collective privilege of the members of the parliament and state legislature. Additionally, it is also contended that the right to personal liberty under Article 21 is not violated, as members possess both individual and collective rights to make decisions in the parliament. Hence, the council humbly submits that the 10th schedule does not violate the rule of law under Article 14, 19, and 21. If your lordship allow, the council would like to move on to the first sub-issue under Article fourth issue.
Yes, we can.
Yes, proceed.
Much obliged, your lordship. Whether the exempted cases and non-exempted cases under paragraph 4 of the 10th schedule is based on intelligible differentia and reasonable classification under Article 14 of the Constitution. It is to be duly noted, your lordship, that the exempted cases means that the members who have merged with the other political party under the provisions of paragraph 4 of the 10th schedule, and non-exempted cases means the members who otherwise defect as per the paragraph 2 of the 10th schedule. The classification between merger and defection is for the purpose of preserving the stability of the political parties. and to prevent arbitrary switch of allegiance. Your Lordship, both merger and defection have different meanings. Merger is more significant change in the political alignment as majority of the members are not content with the current party, whereas defection is more like an individual act of switching parties. This difference between them makes the intelligible differentia. The object of the act is to curtail frequent defection of members. It has been held in the landmark case Ramke Dalmia versus Justice S.R. Tandolkar that Article 14 forbids class legislation but permits reasonable classification based on an intelligible differentia and rational nexus to the object sought to be achieved. Therefore, it can be understood that it is a reasonable classification. The classification here aims to maintain party discipline and to prevent the opportunistic behavior of the members. This difference further helps the political parties to maintain their identity and ideological coherence. Hence, it is humbly submitted that the exempted and non-exempted cases under paragraph 4 of the 10th schedule is based on intelligible differentia and reasonable classification. If your Lordship permit, the Council would like to move on to the final sub-issue in hand.
Before you go to the final submission, how can the Speaker of the Legislative Assembly and Speaker of Lok Sabha be removed from office? What is the procedure for their removal?
The Speaker, in pertaining to the defection cases under paragraph 7 of the 10th schedule, Speaker can be removed. Speaker can be removed and under the 7th paragraph under 10th schedule.
The answer is Article 179 of the Constitution speaks about removal of the Speaker or Deputy Speaker of Legislative Assembly. Clause C of Article 179 states that a Speaker or a Deputy Speaker may be removed from office by a resolution of the Assembly passed by a majority of all the then members of the Assembly. It is clearly stated in the provision that provided that no resolution for the purpose of clause C shall be moved unless at least 14 days notice has been given of the intention to move the resolution. Speaker of Lok Sabha can be removed by the Lok Sabha by a resolution passed by effective majority of the House as per Article 94 of the Constitution of India. The Speaker is also removed on being disqualified for being Lok Sabha member under Section 7 and 8 of the Representation of People's Act 1951. This would arise out of Speaker's wrong certification of a bill as money bill, inconsistent with the definition given in Articles 110 of the Constitution. That is the answer. You can proceed with the final submission.
Yes, Your Lordship. Whether the paragraph 2 is violative of the parliamentary democracy under Article 19, read along with Article 105 and 194 of the Constitution. Article 105 and 194 are mutatis mutandis counterparts of each other. It deals with the rights and privileges of the members of the parliament and state legislature respectively. The rights conferred by these articles encompasses collective privileges for the entire House and individual rights of the elected representatives. In the landmark judgment Quixote Holocaust case, the court held that the provisions of the 10th schedule do not violate any right or freedom under 105 and 194. As it is quoted, that the paragraph 2 of the 10th schedule to the Constitution is valid. The provisions do not suffer from the vice of subverting democratic rights of the elected members of the parliament and the legislature of the states. It does not violate their freedom of speech, freedom of vote and conscience as contended. The provisions of the paragraph 2 do not violate any right or freedom under Article 105 or 194 of the Constitution. The provisions are salutary and intended to strengthen the fabric of Indian parliamentary democracy. Further, the court emphasized that Article 105 and 194 is not an absolute right. The privilege given to an individual members of the party in the House of the Parliament and state legislature is subjective to the restrictions as mandated in Pandit MSM Sharma versus Sri Krishna Sinha, which states that the right conferred upon a member of the parliament is additional right over and above that he has as an ordinary citizen, which is confined to the four walls of the parliament. Also, in case of Kuldeep Bishnoi versus Speaker Haryana Vidhan Sabha, Chandigarh, the court held that the disqualification imposed by the paragraph 2 of the 10th schedule should be without prejudice to the Article 105 and 194. the parliamentary democracy under Article 19 along with 105 and 194 of the Constitution. The Council seeks permission to move on to the prayer.
Yes.
Much obliged, Your Lordship. Therefore, in light of facts stated, issues raised, arguments advanced, and authorities cited, it is humbly prayed that this honorable court may be pleased to hold and adjudge and declare that the petition to be dismissed, and declare that the 10th schedule is violative of the basic structure doctrine. The honorable court may pass any other order or decree as it deems fit in interest of justice, equity, and good conscience. And for this act of kindness, the respondent shall duty bound ever humbly pray. It was indeed an honor to argue before this court. Thank you, Your Lordships.
Yes, judgment reserved. We'll meet after a break.
We are deeply grateful for Honorable Justice Srimati P. Sree Sudha Ma'am and Honorable Justice Srimati Surepalli Nanda Ma'am for adjudicating the final rounds of the 4th National Moot Court competition conducted by Thomas George and Associates, and we are looking forward for the vote.